Please join me in welcoming Camisha Simmons as our presenter today.
Thank you for that excellent introduction. Good afternoon, everyone. Just to give you a little bit more about me, I love this subject, oil and gas, because I'm originally from Victoria, Texas. So I'm from South Texas. Oil and gas is a huge part of the South Texas economy. And right now, it really is, the market is taking a hit. The oil and gas market is taking a hit. So this is very hot topic, I'm pretty sure, for all of you, and definitely for me, because I'm in the restructuring industry when it comes on the legal side. So the current state of the oil and gas market, everyone knows the market's been taking a beating. So just to give you a little bit of background, the price, how many of you are in the oil and gas industry versus other areas of energy? Okay, the majority of you. So all of you know the market has been taking a beating. Started tanking, I guess, around July 2014, so almost 2 years now. It's been fluctuating, it's been volatile, the prices. However, even though it goes up and down, it's still depressed because, for instance, around July 2014, the price of crude oil was about $105 per barrel. And so now, as of, I believe, yesterday, close of yesterday, it was about $40, a little under $40 per barrel. Same for natural gas. Natural gas has been declining and has been depressed for the last couple of years. Around the second half of 2014, natural gas was at 45 per million BTUs, 445 per million BTUs. And then now it's around $1.98 per million BTUs. So natural gas is also taking a beating. It's good for our gas tanks when we're filling up our cars, when it comes to the of course, liquid gas, but not good for everyone in the industry. And of course, I'm pretty sure a lot of your companies, I'm not sure if your companies have, but over the past 2 years, there have been a lot of layoffs. And just to give you background on what's been happening in the bankruptcy area, at least over 35 oil and gas producers have filed for bankruptcy protection. They've sought to restructure over $20 billion in debt, and they're still tanking. As this next slide is going to determine, spring borrowing-based redeterminations are occurring in April. I think April 15th was what the key date, and so that was Friday. Any of you lenders in the room? Okay, a couple of lenders. So you're very familiar if you have some of these reserve-based loans out. This is the month. This is the month for the borrowing-based redeterminations. A lot of companies, if they have the loans out where there were reserve-based revolving credit facilities, most likely their borrowing base is going to decrease. So the amount that's available for them to draw down on the facility is going to decrease. And if they are already suffering from a liquidity crisis, if they're already cash strapped, then they're going to be further cash strapped. And I think we're going to see a lot more bankruptcies over the next 6 to 12 months. So just to give you a little background on what's been happening just last week, actually. Energy 21 just filed for bankruptcy protection last week on April 14th. They are a large natural gas and oil producer. They are mostly offshore. They do mostly offshore. Their operations are off the Gulf of Mexico mostly, and then onshore in Louisiana. And they have reportedly have 1.76 billion in assets and 2.9 billion in liabilities. So this is a large restructuring that's taking place. I'm not sure if any of you are familiar with the law firm Vincent & Elkins, but it got filed in Houston because Vincent & Elkins has the case, because otherwise it would be filed in Delaware or the Southern District of New York. because that's the trend. And then just Friday, we have Goodrich Petroleum Corporation, another producer that filed for bankruptcy protection in Houston, filed by Vincent and Elkins. And they have operations in Texas, Mississippi, and Louisiana. This may be a fast track case because they have a prepackaged reorganization plan. So they have a lot of support already from their major creditors. So they shouldn't be in bankruptcy that long. It's a smaller case. They have liabilities probably slightly over $500 million that they have to restructure. So when you're dealing with oil and gas restructurings, there are a lot of unique issues. I just want to cover some of the key issues that you're going to be dealing with that are unique to oil and gas companies. I'm pretty sure a lot of you are familiar with the habendum clause of the oil and gas lease and the concept of production and paying quantities, and basically an oil and gas lease in this environment can terminate due for failure to produce and pay in quantities because the lease may not be that profitable at this point. And so I just want to cover, in the event that a lease would terminate for failure to produce and pay in quantities, key considerations for parties that are hold interest in those leases that are at risk of terminating. I also want to cover treatment of oil and gas interests in bankruptcy and why that's important, and touch upon safeguarding security interests in certain oil and gas interests, royalty disputes, which is hot right now, and end with preferential transfer avoidance action exposure for contractors at oil and gas projects. So the addendum clause, anybody familiar with oil and gas leasing and the addendum clause in here? One? Okay. So the addendum clause in oil and gas lease basically sets forth the duration of the oil and gas lease. So what you're dealing with is a primary term under the addendum clause that'll provide that the lessee under the lease, you know what a lessee is, right? Okay, the lessee under the lease, usually the oil and gas producer, they will have the lease open for a fixed primary term, usually 2 or 3 years, and then for as long thereafter as oil and gas is produced. So for long thereafter is the secondary term past the initial fixed primary term. So this is an example of a typical addendum clause where it provides under the lease that the lease shall remain in force for a term of 3 years from the date hereof and as long thereafter as oil or gas is produced from said land. So the primary term in this example is 3 years. The secondary term is will be kept open indefinitely. The lease will be kept open indefinitely for as long as oil and gas is produced. But the term produced is actually a little bit more detailed than are you just producing oil and or gas from the particular lease. You have to have production and paying quantities, not just production, to keep the lease open under the typical addendum clause. And so you have to look to state law to determine what production and paying quantities actually really means. This production and paying quantities requirement under the lease traditionally was designed to protect the lessee, the producer, so the producer wouldn't have to be tied to an unprofitable oil and gas lease. However, now landowners are using the production and paying quantities requirement to terminate leases so that they can get rid of leases that they just don't want, maybe lease it to another producer and for a more lucrative deal. Like I said, you have to look to state law to determine how you determine production and paying quantities. We're going to take Texas, for example. Under Texas, you have a two-pronged test to determine whether the lease is producing and paying quantities, whether it's a profitable lease and should be kept open. The first prong is the mathematical test, where you look at whether operating expenses are exceeded by operating revenue over a reasonable period of time. So you're looking at whether or not the lease is operating at a profit under the first prong of the Texas test for determining whether or not a lease is producing and paying quantities. And a number of courts, they look at a number of expenses to make this calculation, but some of the expenses, operating expenses that go into the calculation are the landowner's share of the royalty, labor, marketing, repair costs, depreciation, overhead expenses attributable to the well, and taxes on the operator's interest. So these expenses will be backed out of revenue to determine whether or not the lease has an operating profit. And then the component, it has to have an operating profit for over a reasonable period of time. This is, there's no fixed arbitrary time period that you have to look at to determine whether or not the lease is profitable. So, it could be any particular time period that would allow a reasonably prudent operator to assess whether or not the operator should continue operating the lease in hopes of generating a profit on that lease. So basically, if you fail the mathematical test, you go to the reasonably prudent operator analysis, and as I said, you have to determine whether or not the operator is operating for a profit and not for mere speculation. And determine the entire analysis will require consideration of all matters which would influence a reasonable and prudent operator, including factors such as depletion of the reservoir, the price that the oil and gas is being sold for at the time, the profitableness of other wells in the area, the reasonable period of time, and whether or not the lessee is holding the lease merely for speculative purposes. So I'll skip this. Well, I'll briefly touch on the fact that the length of the lease may be a key factor. I think there was one case out there where they tried to terminate a lease, arguing that it failed to produce in paying quantities. The lessor did, but this was a 50-year lease, and there was only one single brief 1-year period in which the well had not made a profit. And so, after that 1 year of unprofitableness, the well resumed and continued profitable production. So in that case, the court was like, no, this lease, has been profitable over the long run. There was just only one dip. So no, this lease is not, shouldn't be terminated for failure to produce in paying quantities. Just to give you a brief overview of other states, Kansas just appears to only utilize one prong, the mathematical test, to determine whether or not the lease is producing and paying quantities under the addendum clause. Pennsylvania has a two-prong test similar to Texas. So you have the mathematical calculation on the first prong, and then under the second prong, you look at whether or not the operator has exercised good faith judgment in maintaining operation of the well and to reestablish profitability. And just note that other states may take a slightly different approach to that calculation and determination. So how can lessees protect themselves should they be in this situation where they may lose their lease due to unprofitable production, especially in an environment like this where oil and gas prices have been depressed for almost 2 years now? It starts at the beginning of the negotiation process. When you are negotiating the terms of the lease, you can negotiate some sort of savings clause that would keep the lease open for times when there's a short time period where there's a cessation of production and paying quantities, and a very key provision that can protect the lessee in the event of unprofitable production in the environment that we're in now is the right of first refusal to top lease that particular land. And basically, the top lease, the right of first refusal will give the lessee the option to, lease the property. Let's say there's no way to keep this lease alive. It's going to terminate for failure to produce and pay in quantities. That right of first refusal would allow them to enter a new lease that would have a new primary term, and that new primary term would, hopefully ride out this depressed market. And so they can start, producing again when the market improves, and they can operate at a profit. Just quick notes: mineral estate owners, if they're landowners, I'm not sure if we have any in here, but you probably would need to seek court action to seek a declaration that the lease has terminated due to failure to produce and pay in quantities, if you choose to do that. And then, of course, lenders, and I believe lenders have been proactive in this environment. Lenders need to be constantly in contact with borrowers to determine whether or not the leases are actually operating at a profit, maybe requesting periodic reports regarding the financials with each particular lease. So now we're going to move into treatment of oil and gas, certain oil and gas interests in bankruptcy. I want to touch on, which is a big one, oil and gas leases. Gathering agreements for you downstream companies, very big, because there's a recent decision in a case on gathering agreements out of New York, joint operating and joint exploration agreements, farm out agreements, and conveyed interest and production payments. So under Section 365 of the Bankruptcy Code, a debtor in bankruptcy can pick and choose those agreements they would like to assume. So basically, a debtor in bankruptcy has the option to assume those executory contracts and unexpired leases that the debtor deems are beneficial to the debtor's operations. And then the debtor can reject under Section 365 those executory contracts and unexpired leases that the debtor deems are burdensome to the debtor's operations. And the court generally defers to the debtor's business judgment when determining whether or not to approve an assumption or rejection of an agreement in bankruptcy. So in order to be assumable and rejectable, an agreement has to be an executory contract, basically meaning that there must be performance obligations still remaining on with respect to both parties to the agreement, and or it needs to be an unexpired lease. So it has to be a true lease. It can't be a disguised financing arrangement. It can't be a real property interest, which you'll see next is what you're going to be dealing with in some instances with oil and gas leases. So in order for a debtor to assume an agreement, the debtor is required to cure any defaults on their agreement and provide the counterparty to their agreement adequate assurance of future performance. And if the debtor decides to reject an agreement, the counterparty to that agreement will have an unsecured claim for rejection damages for the rejection of that agreement. So just a quick note, if an oil and gas lease, if it's actually considered under state law an executory contract or unexpired lease is actually considered a true lease under state law, then there's a section under 365, subsection under 365 that provides that real property leases, the lessee under those leases can remain in possession for the remainder of the lease term, even though, and exercise the rights appertinent to the lease, even though the lease has been rejected. So that means if and some jurisdictions have concluded that, the particular oil and gas lease was a real property lease. So that means the lessee can remain in possession and continue developing the lease if the development rights are appertinent to the lease. So, I think I covered this, but, let me skip this one. Just to give you a brief overview of how states deal with the characterization of oil and gas leases, to determine whether or not they can even be assumed or rejected in bankruptcy. For Texas, for one, an oil and gas lease in Texas is not a true lease. It's a real property interest. The the lessee holds a fee simple determinable under the lease. The lessor holds a possibility of reverter, so when the lease terminates, the lessee's possessory interest in the mineral estate reverts back to the lessor, landowner, or mineral estate owner. So if you're dealing with the Texas oil and gas lease, it can't be assumed or rejected in bankruptcy. It's just going to ride through the bankruptcy, unless if it expires by its own terms, then it expires by its own terms. But if it continues throughout the bankruptcy, it's just going to ride through the bankruptcy, and both parties are going to be required to perform under that particular lease. Oklahoma, the same as Texas. It's considered an interest in real property, so it can't be assumed or rejected in bankruptcy. Same for North Dakota. Oil and gas leases can't be assumed or rejected in bankruptcy because they're real property interests. Colorado, the same. Kansas is different. Can't really see it here, but Kansas is basically a license to enter upon the land and explore and develop. So it's not a real property interest. It would be considered an executory contract or an unexpired lease. So in that case, in Kansas, you can assume or reject an oil and gas lease in Kansas. Pennsylvania, a little different. Pennsylvania, the rule is not very clear because there's a case out in Pennsylvania, a Supreme Court case that sort of explained that Pennsylvania takes a bifurcated approach to whether or not a lease is a true lease or not. So before oil or gas is produced in Pennsylvania, according to the Supreme Court, then that interest that the lessee has is the right to explore and develop during the agreed upon term. So in that instance, before oil and gas is produced, the lease is generally, it can be assumed or rejected in bankruptcy because it's it would be considered an executory contract or unexpired lease. But after the oil and gas is produced, then the lessee has a vested fee simple to determinable, and so then it turns into a real property interest that can be assumed or rejected in bankruptcy. So this is kind of what the Supreme Court in Pennsylvania had explained in one case, but a later court, not the Supreme Court in Pennsylvania, sort of debunked that and said, no, that's not really the law in Pennsylvania, but the Supreme Court in Pennsylvania hasn't come back and said what they really meant. So it's not really clear what the rule is in Pennsylvania. So offshore leases, that was the discussion of onshore leases. So onshore leases, you're going to look to state law to determine how they're characterized. But offshore leases, a little bit different. Offshore leases are governed by federal law. Federal government has jurisdiction of offshore leases for offshore operations. And so they're governed by the Outer Continental Shelf Lands Act. And the Department of Interior is the actual lessor for these offshore leases. And so basically, when you're dealing with an offshore lease, you look to the federal law to determine whether or not, you look to the state. It's a provision where it says you look to the state law that's adjoining the offshore lease, the land, to determine what that lease is. However, if the state law conflicts with the federal law, then you're going to look to federal law to determine what the interest is. And in some litigation not too long ago in the ATP Oil and Gas Corporation case, the federal government stepped in and took the position that offshore leases are unexpired leases and executory contracts. So based on that position, offshore leases can be assumed or rejected in bankruptcy. It would be interesting to see if the Department of Interior will take that same position in other cases. I briefly mentioned that earlier. So now we get to gathering agreements. Gathering agreements, very interesting for midstream companies. Recently on March 8th, the Bankruptcy Court for the Southern District of New York entered a decision with respect to gathering agreements. And in in that case, there were a couple of companies, Nordum Ford Gathering LLC and HPIP Gonzalez Holdings LLC, and they had entered into a number of agreements with the debtor company Sabine Oil and Gas Corporation. And so Nordum had a gas gathering agreement and a condensate gathering agreement with Sabine. And so according to that agreement, the gathering agreement, Sabine agreed to dedicate all gas produced by Sabine from a designated area and delivered to Nordum, so Nordum could gather, treat, dehydrate, and deliver the gas to Sabine. Nordum agreed to construct a gathering system of pipelines and treatment facilities at its sole cost and expense, and then Sabine was required to deliver certain minimum amounts of gas to Nordum on an annual basis. And then if the minimum amounts were not delivered, Sabine, under the agreements, is required to pay Nordum deficiency payments. And then the condensate or gathering agreement was very similar, but it related to liquid hydrocarbons. And then the agreements with HPIP Gonzalez Holdings, in that case, situation, there was a production, gathering, treating, and processing agreement and a water and acid gas handling agreement, similar to the Nordum gathering agreements, but it related to oil, gas, and water produced from the wells located on the land subject to the certain leases owned by Sabine. So these agreements, the provisions in these agreements provided that these were covenants running with the land under Texas law. And so if they were covenants running with the land under Texas law, they would be considered real property interests that could not be assumed or rejected by a debtor in bankruptcy. And so Sabine sought to reject these agreements despite the language in the agreements that provided that they were covenants running with the land. Of course, Nordum and HPIP, of course, objected to that. And so the court, Judge Shelley Chapman in the Bankruptcy Court in the Southern District of New York, took a look at Texas law, took a look at the agreements, and ultimately concluded that these were not the terms of the agreements. They weren't covenants running with the land. They were, general executory contracts that could be assumed or rejected in bankruptcy. So now, I mean, this is very big for midstream companies. Now, the Judge Chapman hasn't made the decision whether or not these agreements will be rejected. So they haven't come to that point. This is not a binding decision on whether they're going to be rejected. But it's out there, her conclusion is out there that these agreements can be rejected. So midstream companies are at risk should a debtor that they're contracted with file for bankruptcy. These agreements may be rejected in bankruptcy, and that's a big deal, especially if you bear all the costs of actually constructing these facilities. So that's very important in the midstream area. Just a quick note, joint operating and joint exploration agreements, they're generally going to be considered executory contracts, and they can be assumed or rejected in bankruptcy. Just, but always, make sure you check state law and check the agreement provisions just to make sure. Farm out agreements. Farm out agreements, they're actually specifically defined under the bankruptcy code, and so basically they're it's where an owner of a right to drill, produce, or operate liquid or gaseous hydrocarbons on property agrees or has agreed to transfer or assign all or part of that right to another entity. And then so the other entity, as consideration, agrees to perform the drilling, reworking, recompleting, testing, or similar related operations to develop or produce the liquid or gaseous hydrocarbons on the property. So these agreements, farm out agreements, if a debtor has transferred their interests pursuant to a farm out agreement, section 541 of the Bankruptcy Code provides that the debtor's interest that was transferred pursuant to the farm out agreement does not come in as property of the bankruptcy state. So therefore, the bankruptcy court would not have jurisdiction over that interest transferred on the farm out agreement, so it protects the transferee of that particular interest. Same thing for production payments. So when you're talking about production payments, it has a specific definition under the Bankruptcy Code under section 10142A, but basically, it covers what's covered in the definition of production payments as well: overriding royalty interest, and net profit interest. And so these also, if a debtor, transfers his interest, and with respect to these vehicles, they also do not come in as property of the debtor's bankruptcy estate, so the transferee is also protected in this situation. So safeguarding security interests. How many lenders do we have in there again? A couple. So you probably, it's very important in this environment to safeguard your security interests. It's too late once they file for bankruptcy, but so you got to plan early on about this and be vigilant. But of course, state law determines how the interest is characterized, and then how the interest is characterized determines how you perfect that interest, that security interest. And proper perfection, of course, determines priority of the secured interest in the debtor's assets. And for instance, if you have a oil and gas lease secured interest in an oil and gas lease in Texas, let's say, where it's considered a fee simple determinable, in order to perfect that interest, you would have to actually record a deed of trust in order to perfect that interest. And so, if you don't, then you're not properly perfected, and another party may take priority, a prior and superior security interest in that same asset. And so in that particular situation, you're going to be exposed should they file for bankruptcy and you're jockeying for position in trying to get paid on your claim. And so another important area is mechanics liens, statutory liens. And so, you need to be careful about that, because in some states, you gotta look to state law, but in some states, the statutory lien claimants may have priority over other holders of secured interest in the debtor's assets. But that's, has to be a case-by-case analysis of state law with respect to that unique situation. Try to pay attention to federal tax liens. They may rear their head and affect security interests, parties' security interests and assets. And so, just a quick note, it's important. Why this is important is because when a debtor files for bankruptcy protection, you're going to have a number of parties trying to challenge the validity of liens in bankruptcy. You may have a very litigious creditors committee, and because they're unsecured creditors, and so they're going to try to invalidate anything they can invalidate in order to increase the pool available for distribution to unsecured creditors in bankruptcy. So it's very important to safeguard your security interests, but it starts early on and not when they're actually in bankruptcy. You can't do that when they're in bankruptcy. And I just want to briefly go over some other things. Royalty disputes. So this is very big, especially in a depressed oil and gas market. You have, landowners, mineral estate owners that are, their checks are going down, their royalty payments are going down, and so they're disgruntled. And so there are a bunch of royalty lawsuits out there, and they've been commenced over the last couple of years. And they're not necessarily, they don't really relate to oil royalties. They're usually relating to gas royalties that are a little bit more complex calculation, and so a little bit more room for argument as to how to calculate the royalty. And for instance, Chesapeake is embroiled in a lot of litigation, a lot of money on the line. I think they've settled some of the cases, but they still are taking a beating. They're still, caught up in litigation. I think their stock price is very, very low right now. I didn't check it this morning, but they're not doing too well. I'm not sure if they're on the watch list for bankruptcy, but I think at one point, I know they have a restructuring counsel, but I think at one point they said, oh no, we're not gonna file for bankruptcy, but we'll see. And there's also been some royalty dispute litigation going on in the Sampson Resources Corporation bankruptcy. They filed in Delaware, bankruptcy protection in Delaware. So in that case, the U.S. trustee has been lobbying. I don't think it's happened yet. The U.S. trustee is trying to get an examiner appointed, and one of the things the examiner would do was investigate the the royalty dispute claims of the particular landowners in that case. And then the landowners also have been trying to push, I don't think it's happened, but they've been trying to push to get a special committee put together to represent the special interests of the landowners with respect to their royalty interests in the bankruptcy. So royalty disputes, when you're dealing with this market, are very big. They're ongoing right now, and you know, very interesting litigation, and they may carry over into the actual bankruptcy proceedings. So this is a very interesting thing that goes on in bankruptcy, is that under section 547B of the bankruptcy code, a debtor in possession, or sometimes it may be the liquidating trustee under a trust or litigation trust that's set up under a plan of reorganization, they're going to try to go back and claw back any payments that were made to creditors within 90 days of the bankruptcy filing. And they can go back further if it's an insider of the debtor. So the contractors at oil and gas projects are, you know, very exposed to this clawback litigation. And just to go over what the provision provides, you know, a trustee or a debtor possession in bankruptcy can avoid any transfer that was made to or for the benefit of a creditor for or on account of an antecedent debt owed by the debtor before the transfer was made. It was made while the debtor was insolvent, and it was made on or within 90 days before the date of the filing of the bankruptcy petition, or between 90 days and 1 year before the date of the filing of the petition if the creditor was an insider at the time of the transfer. And basically the transfer would have to enable the creditor to receive more than the creditor would receive if the case was basically a hypothetical Chapter 7 liquidation situation. So any contractor or provider of goods and services at an oil and gas project, if they received payment within 90 days of the bankruptcy filing, and any other creditor of an oil and gas company that receives payment within 90 days of the bankruptcy filing, may be sued for recovery of those payments if they were made on the eve of the bankruptcy filing. So there's really not a defense for the statutory lien claimants that receive payment, and instead of filing a statutory lien, fixing a statutory lien, they just receive payment. They didn't have to file the lien. And section 547C6 of the bankruptcy code actually provides that the fixing of a statutory lien cannot be avoided. So if they would have fixed the statutory lien, they would be protected from the clawback provision of the bankruptcy code. But these goods and service providers at these oil and gas projects that are exposed to this preference litigation, they're being proactive now. I'm currently co-counsel to 13 oil and gas service companies in the Sabine Oil and Gas Corporation case in New York, whereby we filed a proactive notice asserting that these payments can be clawed back, and because there's case law out there that provides that, you know, for one, the Bankruptcy Court in Eastern District of Tennessee has provided that under section 547C6, attachment or perfection of the statutory lien during the preference period is not avoidable, thus payment to prevent attachment or perfection of the statutory lien may not be avoidable also. And Southern District of New York also has provided that payment itself should not be less secure than the lien which could have secured it. So, you know, just know that if you're, I don't know if any attorneys in this room, or if you're one of these contractors that are providing goods and services at oil and gas projects, just be aware that if you are sued for a clawback payment, it's good to assert this particular defense, even though it's not codified. At least you can, you know, assert it, citing the case law out there on that proposition. Well, thank you for your time and your great questions.